members would take their seats. It's 9 o'clock. We are live streaming, so you're on the air. First up, Representative Burris, you're on Webex. Are you in the building?
Yes, Mr. Chairman, I'm in my office.
Thank you. Eric Smith?
I am in my office.
Thank you. We will be taking up a bill that we'll be voting on, so we'll have to come back to you on that. Committee, we're going to take this up I hope, quickly, and then we'll start the hearings. First up, I would like for you to look at your files in Senate Bill 126, Alcoholic Beverage, the Club Establishment Act. Matt, would you give us an overview, please?
Thank you, Mr. Chairman. Good morning, committee. Senate Bill 126 would allow a Class A club licensee to host events during which the licensee could sell and serve alcoholic liquor for consumption on the premises to individuals other than club members and their families and guests. A Class A club, as a reminder, means a premises that is operated as a nonprofit, social, fraternal, or war veterans club. And under current law, Class A clubs are allowed to sell and serve alcoholic liquor to members of the club and their family. The bill would allow the club to sell and serve alcoholic liquor to non-members during specified events. And happy to answer any questions.
Thank you. Committee, if you recall, this is the one that came to us from Senator Olson. They have a couple of legions and other fraternal organizations that have built large rooms, and they would have wedding receptions and anniversary receptions, particularly 50 years anniversary and those type of things. So it passed the Senate with a very, I don't have that number, but it was in the 30s. So I would look to the committee. What is the pleasure of the committee? Representative Berger?
Mr. Chair, I move that we pass out Senate Bill 126 favorably for passage.
Second by Representative Reese. Discussion, Representative Arnberg.
Thank you, Mr. Chair. I have an amendment.
Has the amendment been handed out? Would you do that? And would you explain your amendment once being handed out?
Yes, I'll briefly explain, and then if Matt can explain, and then I'll tell the backstory behind it.
Okay.
This is agreed upon language between some folks in the alcohol, liquor industry and restaurant industry and Debbie Beavers. You'll notice it looks really long, but we have to add in a statute to make this work. And so that is why, if you notice on the attachment, that is already current statute, and you'll notice that there's an ablution amendment in there as well. So. Thank
you, Matt, if you would.
Thank you, Mr. Chairman. The first few changes in the balloon are just to basically accommodate the change that's in the attachment. So the attachment would insert KSA 412640 pertaining certain sales practices for club and drinking establishments. If you go down where there's the strike in addition, it would clarify that a licensee could sell or serve beer, cereal malt beverage, or mixed alcoholic beverage in a pitcher. The pitcher is then, as well as the mixed alcoholic beverage, are defined for the purposes of this section on the last page of the attachment. And be happy to try to answer questions about that.
Thank you, Matt. I have one question. When I talked with Debbie Beavers, she said we needed to define what a mixed drink or mixed beverage is. So that helps. So this does make that definition. Is that correct?
Yes, that definition of mixed alcoholic beverage and definition of pitcher are on the last page of the attachment, and they're only for the purposes of this section, not the entire Club and Drinking Establishment Act.
Thank you. Question for the carrier of the amendment. I understand that this is compromise language between the ABC and the Beverage Association.
Yes, the reason this is getting brought forward is over the past weekend, a restaurant was cited for selling a bucket curbside to go of Long Island iced teas, and in current statute, that is not allowed. And in order for it to be allowed, there has to be a separate form to be filled out and approved by the director. Well, obviously, we have curbside to go is still a thing in Kansas, and we want it to keep going. So we need to clean up our statutes and allow this to happen.
Yeah, I'm glad they came up with this compromise language, because initially, when I talked with the commissioner of ABC, the director of ABC, she thought it was very important that the original amendment did not have a definition of what a mixed drink or mixed beverage is. So she did get that in there. With that, I'll open it up for discussion. Yes, Representative Miller.
Thank you, Mr. Chairman. I'm not finding those definitions.
Matt, I think those are on page 2.
So, thank you, Mr. Chairman. So if you go to the very last page of the balloon, so there's the insert of 2640, and at the very last page,
Actually, it's the second page. That's why I got lost. It is the second page.
Right, second page, where it says a mixed beverage means a beverage that is made by combining alcoholic liquor with a non-alcoholic liquid or other edible substance. Kind of interesting, edible substance. I'm assuming that's the olives.
That'd be a tumbleweed.
Okay. At least 25% of non-alcoholic liquor or edible substance, including but not limited to margaritas, sangria, daiquiris, and mojitos. Never had one. Was that helpful? Thank you. Further discussion? Yes, Representative Howe.
Thank you, Mr. Chairman, and this may go to the reviser, but under the definition of a mixed alcoholic beverage, you're talking about volume and the content of that volume, but you're not specifically addressing the alcohol content. Is that correct?
Matt?
yeah, it doesn't. I don't believe that addresses the alcohol content. Just the 25% of the non-alcoholic liquid needs to be some or other edible substance.
Is that helpful? Thank you. Further discussion? Yeah. Do I have a second now? Representative Reese has got the second. Amendment has been offered. It's been explained and seconded. You may move your amendment.
Thank you, Mr. Chair. I move my amendment.
Thank you. You have heard the amendment of Representative Arnberg to amend House Bill 126. No further discussion. All in favor, say aye. Those opposed, no. Ayes have it. Ayes do have it. The bill is amended. Go back on the original bill. Further discussion? Seeing none. Representative Arnberg.
Thank you, Mr. Chair. I move Senate Bill 126 to be passed out as amended favorably for passage.
Thank you. You have heard the motion by Representative Arnberg to pass out Senate Bill 126 as amended favorably. All in favor, say aye. Those opposed, no. Opinion of the chair, the ayes have it. The ayes do have it. I got one here. It was Epley. I'm sorry. I usually just point, but I beg your pardon. All right. Second, it's been passed out. Now we're going to the hearings.
Mr. Chairman, have my vote recorded, please?
Could he be recorded as a yes vote? Yes. Representative Heiberger. Folks, we scheduled this a week ago, and of course, as we all know, at the starting at the end of the session, we have to move things around, and I did apologize to both bill sponsors. So we're going to do this today. Of course, the Senate's meeting here at 10:30, so we have a limited amount of time. So first, I'll start with House Bill 2251. Matt, if you'd give us an overview.
Thank you again, Mr. Chairman. Good morning, committee. House Bill 2251 would require the court require a court to issue an order requiring a defendant to relinquish all firearms that were in the defendant's custody and any concealed carry license that had been issued to the defendant upon the court's issuance of a qualifying protection order against the defendant or the conviction of the defendant for domestic battery or any misdemeanor for a domestic violence offense in KSA 216301. Under the bill, the defendant would have to comply within 24 hours of the issuance of the order if they were physically present in the court, or would have to comply when the order was personally served on them by a law enforcement officer. If it was personally served, the law enforcement officer serving the order would require the defendant to immediately surrender all firearms in the defendant's custody and any concealed carry license. The officer who takes possession of the firearms or license would issue a proof of relinquishment or removal to the defendant that included the name of the defendant, the date such time or concealed carry license was relinquished, the ID number of any concealed carry license, and the make, model, and serial number of any relinquished firearm. Within 48 hours after the issuance of a relinquishment order, a defendant that was subject to such order would be required to file proof of relinquishment showing that they had complied with the order and attest to the court that the defendant did not have any firearms in their custody. If the defendant failed to file any proof of relinquishment after 48 hours from the issuance, the clerk of the court would issued the order would notify the sheriff of the county that the defendant had failed to make any such filings with the court. Upon receipt of that notification, the sheriff would make a good faith effort to determine whether there was evidence that the defendant had failed to relinquish any firearm in the defendant's custody. A relinquishment order would be effective for either the duration of the qualifying protective order issued against the defendant or for the period of time during which it was unlawful for the defendant to possess a firearm under either KSA 216301 or 6304. Upon the termination of a relinquishment order, and at the request of the defendant, any items that were relinquished or removed by the sheriff will be returned to the defendant, provided the sheriff conducted a state and national criminal history records check, including an inquiry of the National Instant Criminal Background Check System, and confirmed that the defendant was not currently prohibited from possessing or receiving a firearm under state or federal law. The bill would allow a sheriff to dispose of any firearms relinquished by a defendant pursuant to a relinquishment order only after the defendant was notified of the pending disposal of the firearm, and the proceeds from the disposal of the firearm would be paid to the defendant. Lastly, the section provides definitions for concealed carry license, defendant, intimate partner, plaintiff, and a qualifying protective order. Moving to section 2 of the bill, it would make it unlawful for a person to possess a firearm or concealed carry license that was issued to the person while there was a relinquishment order issued pursuant to section 1. Violation of the section would be a severity 8 level non-person felony. It was not a violation of the section if the person was possessing or transporting a firearm for the sole purpose of relinquishing the firearm or concealed carry license. Moving to section 3, it would amend KSA 223426 concerning information that was recorded by a court when judgment was rendered or a sentence of imprisonment was imposed. The court would be required to issue a relinquishment order against the defendant pursuant to section 1 for convictions of domestic battery and any misdemeanor for a domestic violence offense. Section 4 would amend KSA 603107 concerning protection from abuse orders to require the court to issue a relinquishment order pursuant to section 1. And section 5 would amend KSA 60-31A06 concerning protection from stalking orders to require the court to issue a relinquishment order pursuant to section 1 upon issuing a protection from stalking order. Quick run through, happy to try to answer questions that the committee might have.
Thank you. Questions for the reviser? Yes, Representative Russman.
Thank you, Mr. Chairman. Matt, in the bill, does it describe disposal and how that's supposed to occur?
Yes, thank you, Representative. So in subsection J of section 1, it says a sheriff may dispose of any firearms relinquished by a defendant pursuant to a relinquishment order issued under subsection A2 only after the defendant is notified of the pending disposal of any such firearm and the proceeds from the disposal of such firearm, less the cost to the sheriff for taking possession of, storing, and disposing of any such firearm shall be paid to the defendant.
And on the relinquishment order, I think in the bill it mentions that a search can occur also.
Yes, let me pull that up.
And I was just wondering, while you're looking at that, how does that differ from a search warrant?
So, okay, if you go to subsection C3 in section 1, it's discussing if the order is personally served on the defendant, the law enforcement officer is required that the defendant immediately surrender all firearms in their custody. Under that subsection, the law enforcement officer shall conduct any search of the defendant that's permitted by law for such firearms or license. The law enforcement officer shall also take possession of any firearms and license that are relinquished that are in plain sight or discovered pursuant to a lawful search. If the officer had a search warrant, they could exercise that in taking possession of those firearms. If they did not, then it would have to be something that was either related to an element of a crime or was in plain sight, or there was a consent to the search by the individual.
I was just concerned that on a search warrant, it's a person, place, or thing that is mentioned in the search warrant to be taken in a relinquishment order. It's just to turn everything over. And I think that's a problem.
I understand that. We'll move along to
Thank you, Mr. Chairman. Hey, Matt, on your bill brief, page 2, middle of the page, starting at section 2, go down to the last sentence, it would not be a violation of this section if the person blah, 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 or concealed carry license. Does that mean that if a guy has a concealed carry permit in the state of Kansas, he's exempt from that?
Thank you, Representative. No, it's saying that if an individual was subject to a relinquishment order and they were in the process of relinquishing their firearm or a concealed carry license, they would not be in violation of this section for their possession or transport of the firearm or concealed carry license.
So why did it say concealed carry license?
As part of a relinquishment order, if you're subject to a relinquishment order, you have to turn over your concealed carry license. And so it's saying if you're in the process of bringing that to turn it over, it's not a violation to possess that still, even though you're subject to the order.
Thank you, Mr. Chair.
Thank you. Oh, Representative Smith, you're on Webex.
Yes, thank you, Mr. Chair. My question to the reviser is, I'm trying to figure out, is there any anywhere in there, I'm not reading, where a relinquishment might be, where we could turn them over to family members instead of taking them in possession ourselves as law enforcement, I guess.
I don't think there's anything in the bill that would address that.
Thank you.
Thank you. No further questions of the reviser? I'm sorry? Representative Hoyt. Oh, you were pointing down here? Okay, all right.
Thank you, Mr. Chair. As part of the process of being able to have this relinquishment order to transport firearms to either the sheriff or a federally licensed gun dealer, is it there is also the option that the individual, the convicted domestic abuser, could have the federally licensed gun dealer sell it for them if as opposed to having it be stored.
Is that a question for Matt, or is that just a statement?
For the question for the reviser, please.
Thank you. Matt?
So if you look at the relinquishment of the firearm, it's done either to the sheriff or to a federally licensed gun dealer. The disposition of the firearm is spelled out by the sheriff. The bill does not specify how that would be done with a federally licensed gun dealer. So I think that's something that could be worked out between the individual subject to the relinquishment order and the federally licensed gun dealer.
You. I had another question. Was it Representative Wagner? I'm sorry.
Thank you, Mr. Chairman. Matt, what are the current grounds for relinquishment of firearms? I mean, basically, what does it take currently as far as protective orders, or what level of misdemeanor or felony does it currently in Kansas statute?
This section for relinquishment order is a new section established in law in terms of things that would cause an individual to lose their rights to possess a firearm. I'm gonna need to look that up and get back to you with a complete answer.
Thank you. No further questions. I'm going to start with the conferees. Because of our time limit, I'm going to take up LaTanya Boyd first. Ms. Boyd, if you'd come forward. We have your written testimony. What have we decided? You get 3 minutes. And please watch my vice chair. She'll give you the 30-second notice. And good morning and welcome to Federal and State Affairs. If you pull the microphone down some, and is the microphone on? Randy, if you would push the button for her. Thank you, ma'am.
Good morning, Chairperson, member of the Federal State Affairs Committees. My name is LaTanya Boyd. I am from Topeka, Kansas, and I would like to let you know that my life was forever changed on October 13th of 2009 by the domestic homicide of my 21-year-old daughter, Taisha McNair. Taisha was the mother of 2 children, a 5-month-old baby girl and a 2.5-year-old daughter, too. Taisha was shot to death multiple times by her abuser, a person who should not been able to get his hand on a gun. He was convicted of domestic violence. He was in jail. He was let out, and 10 days later, my daughter was murdered while she was trying to leave this domestic violence relationship. I volunteer with Moms Demand Action to ensure that no other parent or family has to go through what I have been through and my family has been through. Right now, women and families in Kansas remain in danger. And I never want any parent to go through the kind of pain that I go through every day. It's a pain I would not want to wish on anyone. Please keep women, families safe from abusers by making sure their guns that they may already have will be relinquished to a law enforcement agency. Please strengthen the public safeties by passing HB 2251 to keep women and children and families safe from abusers. And I would like to share a little bit about Taisha. Taisha was a family person. She had siblings, a sister and 2 brothers. She was very protective of them. Taisha would be a very giving person. Whatever she could do for you, she would. She had just accomplished by getting her CNA, which she was really looking forward into that kind of job because she loved people. I struggle every day. Every day is a big struggle for me to come outside, get out of my bed. And this is why I am here today, to make sure no other family has gone through what I've gone through. Thank you for listening to me.
Thank you, ma'am, and thank you for coming in and sharing your story. Next up is Dina Hubbard, MD, American Academy of Pediatrics, on Webex. Dr. Hubbard, are you on Webex?
Yes, I am.
Okay. You get 3 minutes. Thank you.
Thank you, Mr. Chairman and members of the committee. My name is Dr. Dina Hubbard. I'm a pediatrician and neonatologist, and I'm here today representing the pediatricians of Kansas for the Kansas chapter of the American Academy of Pediatrics and as their public policy chair. Today, I would like to provide testimony in addition to my written testimony in support of House Bill 2251 to remove firearms from those individuals deemed at risk of harming others based on orders of protection for a domestic violence offense. I've heard lots of concerns about protecting guns and abusers. I'm asking you to please consider protecting the women, children, and families of Kansas. Domestic violence does not discriminate. It does not discriminate based on your class, your race, ethnicity, your political views. It affects everyone. The effects of domestic and intimate partner violence also extend beyond that of the abuser and the victim. This involves children, families, as you just heard, and law enforcement who must respond to these. Children suffer significantly, and that's what I would like to share with you today. A third of children under the age of 13 who are victims of gun homicide are deaths related to intimate partner violence or family violence. For those who survive, they endure a lifetime of trauma. That includes post-traumatic stress disorder, behavior issues, school performance, their own mental health and well-being, suicide, and that trauma causes health effects into adulthood. Children, investing in children is a great return on investment. Just like there are rules and laws about cars, if you have too many speeding tickets, you have too many violations for whatever reason, your license, your right to drive is removed. I would ask you to protect Kansas women, children, families, communities with that same rule. I'm asking you to vote yes on House Bill 2251 for Kansas children, families, and communities. I've seen the impact of this on my practice. Early in my training, I responded to the ER. As a neonatologist, I attend high-risk deliveries. And I was called because there was a mother who was a gunshot victim. She was 28 weeks pregnant, and I responded to that. Both the baby and the mother died. Human life is so important. And again, investing in our children is very important. Please vote yes on this bill. Thank you.
Thank you. We'll have questions at the end. Next up is Lindsey Ford, Kansas Coalition Against Sexual and Domestic Violence on Webex. Are you on Webex, ma'am?
Yes, I am here.
Please go forward. You have 3 minutes.
Thank you. Chairman and members of the committee, thank you so much for the opportunity to testify today. My name is Lindsey Ford, and I'm the staff attorney. I'm sorry, I just realized my video wasn't on. I apologize. My name is Lindsey Ford, and I'm the staff attorney with the Kansas Coalition Against Sexual and Domestic Violence. We represent 26 agencies from across the state of Kansas that provide services to victims of domestic violence and sexual assault. I'm here today in support of House Bill 2251. This bill is important and unique because we don't often see legislation that can actively save lives. I've included several statistics in my written testimony about intimate partner homicide and the presence of firearms. For the sake of brevity, I'll only repeat one of those for you today, and that is the fact that the presence of a firearm in a domestic violence situation makes it 500 times more likely that an intimate partner homicide will occur. It's 500 times more likely that someone will be murdered simply because a gun is present. And as you've already heard from some of the other conferees, domestic violence remains a significant cause of death for the women in the state of Kansas. Women are dying, and Kansans are dying, and you have the power to change that by supporting this bill. And with that, I'd just again like to say thank you for even considering this, and at the end, I would be happy to stand for questions.
Thank you, ma'am. We'll take those at the end. Marcia Myersick, Moms Demand Action on Webex. Are you on Webex, ma'am?
Yes, I am. Thank you for listening.
Thank you. Go forward. You have 3 minutes.
I would like to second the comments of the first speaker. Our daughter, Erin, feared for her life, and she had been in counseling regarding her on and off abusive situation, and he was very controlling. Her husband, Gary, as you see the pictures behind me. They both attended counseling until he declared it was doing no good, and he did not agree with what he was being told. In early February of 2014, Gary's primary care physician suggested that Gary had bipolar disorder and wanted to set up an appointment with another doctor to help Gary. This was one of the factors in what happened a few days later when the homicide and suicide occurred. The two deceased left behind their 3 boys of the home and their parents and grandparents. Many families are affected by domestic violence, and access to a firearm in a domestic violence situation increases the chance of a woman being killed by her abuser by 5 times. Under current Kansas law, domestic abusers are prohibited from possessing guns. However, there is no mechanism to actually remove those guns from their possession. HB 2251 requires those who have become prohibited because they are subject to a valid domestic violence restraining order or because they have been convicted of a domestic violence misdemeanor to turn in their guns to law enforcement. This is not a red flag bill. This bill is about protecting vulnerable women and children in Kansas. This bill would only impact people who have been found guilty by a court of a misdemeanor crime of domestic violence or are under an active domestic violence restraining order. Kansas already prohibits these individuals from possessing firearms. We just want the legislature to finish what they started in 2018 by closing the last loophole. We must do something to protect the women and children involved in these volatile situations. Thank you that with your legislative support, our families and society can be safeguarded. Thank you.
Thank you, ma'am. Next up is Amanda Winch. Moms Demand Action on Webex. Amanda, are you on Webex?
I am. Can you hear me?
Yes, ma'am.
Okay. Thank you to the chair, the vice chair, and to the committee for the opportunity to testify before you today. And I also just want to extend my gratitude to the other conferees for their emotional testimony today. My name is Amanda Winch. I'm a lifelong Kansan. I grew up in Wichita, Kansas, and I now reside in Overland Park, Kansas with my family. I'm a parent of 2 young boys and alumna of Kansas State University, and I'm also the volunteer Kansas chapter leader of Moms Demand Action for Gun Sense in America. We're a nonpartisan grassroots gun violence prevention organization dedicated to advancing policies that respect the Second Amendment and protect our communities from gun violence. On behalf of the thousands of Moms Demand Action supporters in the state of Kansas, we ask for your support on HB 2251. I recall as a volunteer with Moms Demand Action in 2018 how both parties worked together to put the safety of their constituents first and passed a common sense bipartisan bill which prohibits most domestic abusers from possessing firearms. That bill was signed into law by then Governor Collier, and several of you on this committee supported that bill. Now we are asking you to take another step to enforce the existing law and make sure that abusers do not have access to guns by requiring them to turn in any guns that they may already have. Every month, an average of 53 women are shot and killed by an intimate partner. Specifically in Kansas, between 2015 and 2019, at least 157 people were killed in domestic violence homicides. We do not know the number of lives impacted by domestic violence yet in 2020, but we do know that domestic violence always spikes during times of prolonged financial stress, and Kansas lost more than 100,000 jobs during the COVID-19 pandemic. We also know that there's been a historic surge of gun sales during the pandemic, putting an unprecedented strain on our background check system and increasing the likelihood that sellers would be forced to sell a gun to an abuser who should be denied when a background check takes longer than 3 days. It is our responsibility to our fellow Kansans to make every possible effort to ensure that women and children are safe from their abusers. The circumstances of the pandemic have increased the likelihood that there are now more guns in domestic violence situations. Ensuring guns are removed from already prohibited abusers is just common sense and will save lives. Passing HB 2251 would strengthen Kansas's existing gun laws and give law enforcement the tools they need to protect women and children. Please put safety first and support HB 2251. Thank you for your time.
Thank you, ma'am. Committee, are there questions for the conferees? Yes, Representative Reese. You'll direct it to one individual.
I would like to direct this question to Dina Hubbard, Dr. Dina Hubbard on Webex. Dr. Hubbard, you've seen the atrocities of gunshot victims, young and middle-aged and probably old as a doctor. What do you feel about people telling you that your legislation, proposed legislation, would deprive me of my Second Amendment rights?
I think of the phrase, your rights, to say, punch me in the face, end where your fist ends and my nose begins. I think when we talk about rights, it's important that when that affects the health and well-being of other people, that no longer is it just about your rights. And so that's why we have to, laws are in order to protect the most vulnerable. And those are our children and women and families in these horrible, horrible situations. And when we know we can prevent harm, there are things that we cannot prevent. But when we can prevent harm with some common sense legislation, this isn't taking away guns. This isn't banning guns. Again, it's like the cars. If you have to be able to have correct vision to have a license. You have to renew your license. You have to do training and practical to have a car license. We just want those common sense things to apply to guns as well.
Thank you. Further questions? Conferees, Representative Wagner.
Thank you,
If
Mr.
you'll
Chairman.
identify the individual.
Yes, Amanda Winch of the Moms Demand Action. If you would take a question. In the third paragraph of your testimony, you talk about the likelihood that the background system is not going to red flag an abuser. Do you have specific evidence on that? Or, I mean, gun sales, if I think the statistics show, have been at a very high level for the last 10 years. And I'm just wondering if you have a specific situation or this is speculation.
Yeah, our research with Everytown for Gun Safety shows that during the pandemic, twice as many guns were sold as in the prior year. I don't have the exact number of guns that would be, but and then there is also evidence, and I can send you some follow-up research on this if you would like. That has put a strain on the background check system for federally licensed dealers, and there are times where in selling a gun, it goes longer than the 3 days, and federal law requires them to sell a gun if the background check is not complete within 3 days. And often domestic abusers or people in the domestic violence category, those background checks can take longer than other prohibited categories to complete as well.
Thank you.
May I comment?
No, you've not been asked a question. Further questions from the committee? I don't mean to sound rude, but we're on a time schedule here, and my committee members have questions. I need to direct them or allow them to go first, because they're the ones that may have to vote on a bill at some point in time. But seeing no more, we're going to close this portion of it. We will direct the committee members. There is a number of written proponents. It is on your agenda. If you would please look at that. We will now go to the opponents. The first opponent that I have listed is the Honorable Merlin Wheeler, District Judge, 5th Judicial District, Kansas District Judges Association, on Webex. Judge Wheeler, are you on Webex?
I am. Can you hear me?
Yes, sir, I can, and it's good to see you.
Nice to visit with you. Chairman Barker and committee members, thank you for the opportunity to address you to express the opposition of our association to House Bill 2251 in its present form. I am Merlin Wheeler. I'm the Chief Judge of the 5th Judicial District. In my written testimony, I've also indicated that I'm joined by our President, Dan Kreitz of the 31st Judicial District, as well as our co-chairs, Judge Glenn Brown and Judge Thomas Kelly Ryan, respectively of the 23rd and 10th Judicial Districts. I wish to remind the members of the committee that our association's opposition is not intended to, in any way, as an expression of opinion about firearm ownership or Second Amendment freedoms, nor do we at any time intend to discount the heartache and loss suffered by the victims of gun violence. We live with those matters daily, the same as they do. We hope that the action taken recently by the House Appropriations Committee to fund additional CSO positions and salary increases necessary to enable us to get to a full staffing situation and avoid the staff reductions that we now have, as high as 27% in Johnson County. However, the reality is that even with full staffing, the mandates of House Bill 2251 may well exceed our human and technological capabilities. In written testimony, I've detailed the challenges this legislation would pose for us. We've also pointed out other issues dealing with the bill, such as tracking the proof of relinquishment and requirement of notices to law enforcement. In addition, we also noted some issues with the unprecedented search warrant opportunities extended under this bill. I neglected in my written comments to note that both state and federal law do make it unlawful for defendants subject to a protective order and felony offenders in Kansas to possess either a firearm or ammunition. The issuance of a protective order also requires an entry into the NCIC, National Crime Information Center database, as a permanent record. I think my written testimony pretty much otherwise sums up our position. I'm happy to answer any questions, and I thank you very much for the opportunity to address the committee.
Thank you, Judge Wheeler. We'll come to questions in just a little bit, if you could remain on. Next up is Dennis Butler, Kansas Association of Chiefs of Police and the Kansas Peace Officers Association. Good morning, sir. Welcome to Federal and State Affairs.
Good morning, members of the House of Federal and State Affairs. My name is Dennis Butler, and I'm the director of the Riley County Police Department. I come before you as a member of the Kansas Association of Chiefs of Police and the Kansas Peace Officers Association, who designated me to represent their interests on House Bill 2251, which they oppose. I submitted extensive written testimony to you. I hope you had an opportunity to read it. I think it's important for those in the room to know that I've been a police officer since 1980. And if there's one topic that I have devoted most of my professional life to, it's the issue of domestic violence and sexual assault in terms of enhancing law enforcement response to those issues. It's something that I often felt alone as a chief and a director in the law enforcement community with the efforts and the passion with which I have approached this. I want to acknowledge the concerns shared by the proponents of this bill. It's heart-wrenching, I've seen it, and it's real. And their feelings are something that our members and myself take very, very seriously. But as you could see in my written testimony, we have serious concerns about the due process aspects of this bill under the 5th and 14th Amendments. I don't need to go into the details of that. You all can read what I wrote. You also have a judge that just testified that could answer those questions better than I. But also the substantial increase in personnel resources is not something to take lightly. The judge of the 5th District just described his office's challenges with that, and I can, again, as I wrote in my written testimony, share those same concerns about law enforcement, especially sheriff's offices. As you know, Riley County does not have a sheriff, so I serve in that capacity as the director of the countywide police department. The storage space, I talked in my testimony about an accredited department. I've been in 3. accredited departments, the standards that we impose on ourselves voluntarily regarding chain of custody and storage is significant. And if we were faced with a flood of firearms that we had to confiscate temporarily or permanently, it would, in my opinion, be very cost prohibitive, not only for us, but for others facing the same situation. There's vague language in the bill. There's a language in there that I heard mentioned by the reviser about good faith effort. Well, police officers operate under laws that are specific, especially when it comes to case law and statutory law. And good faith is confusing to us, and that's language that should not be in that bill. I want to close just by saying again, sincerely, we share the goal of enhancing survivor safety for domestic violence and sexual assault. But these well-intended efforts in this bill fall grossly short, and in my opinion, even create a false sense of security for survivors if the bill in its current form were enacted, because I just don't believe that law enforcement is capable of fulfilling the obligations legally outlined in this bill. Thank you very much.
Thank you, Director. Next up is Special Deputy Greg Smith on Webex. Senator Smith, or former Senator
Good morning,
Smith,
Mr.
are you
Chairman.
on?
How are you? Good to see you
Good
again.
morning, sir. Good to see you.
Good morning. Good morning, committee. Thank you for allowing the Johnson County Sheriff's Office to testify on this bill. Our concerns are all legal concerns. This is not an opinion on gun ownership, Second Amendment rights. Certainly is not any aspersion against a victim of domestic violence. We work tirelessly to try to do as much as we can to prevent that crime and work with victims afterwards. But there's a lot of confusion in this bill, and we have a lot of concerns, not the least of which is constitutionality. Very quickly, I'll go through some points. We contacted several of the FFL dealers in Johnson County. There are hundreds. Obviously, I wasn't able to contact them all, but every single one of them that I contacted and discussed this bill with was concerned that they were going to be a quote unquote relinquishment center. They're not in favor of that. They also expressed concern that some of these weapons will be turned back over to the defendant. And what happens while they're storing these weapons, what happens to them while they're storing these weapons if there's damage to the weapons, if their shop is broken into and those weapons are stolen? There's no type of immunity for them whatsoever. For that matter, the sheriff's offices that are charged with storing these weapons also have no type of immunity for any of these types of things that could happen to these weapons. Secondly, and probably most importantly, there's a Supreme Court case from 2015, Henderson versus the United States, that is specifically on point on this type of case. Briefly, Henderson was required as a bail condition to turn over all of his firearms and did so. He then, after pleading guilty, asked to have his firearms given to a friend, and the court refused, believing that it would give him constructive possession of the firearms. However, this was appealed all the way up to the U.S. Supreme Court, who vacated this order and said, don't make the mistake of confusing possession and ownership. It's quite all right for ownership, but not possession under these types of statutes. And there's nothing that says that the court can't allow those weapons to be given to another person as long as the court is satisfied that there's no constructive possession for the defendant or the convicted person. This was a unanimous opinion of the Supreme Court, so we have doubts as to the constitutionality of the mechanisms that are in this bill. Also, counties don't issue CCW licenses, so we're kind of confused on why we would be the one that would confiscate them. They're issued by the state, by the Attorney General's office. Perhaps this is something that the court should do or the Attorney General's office should do. And then lastly, some of domestic violence cases and these types of orders are done in a municipal court, and the Johnson County Sheriff's Office does not intervene in municipal court actions, and any type of seizures or things like that would fall under a municipal court jurisdiction and municipal officers. Those are our main objections to the bill, Mr. Chairman. As I said, this is not any kind of aspersion to the victims of these types of crimes. We are very sympathetic to those victims and work tirelessly to try to prevent this type of crime. Be happy to stand for questions at the appropriate time.
Thank you. Moving right along to Sheriff Cole Presley, Kansas Sheriff's Association by Webex. Sheriff Presley.
Good morning, Mr. Chairman. Thank you for the opportunity to appear. Would like to have done it in person, but we're obligated in other areas. Sheriff Jeff Easter, our legislative coordinator, should have submitted to you written testimony that in large part is somewhat redundant to what you've heard from Director Butler and from Mr. Smith. And I don't want to continue to be redundant this morning, except to highlight that the Supreme Court case Henderson versus U.S. is very concerning to us. The inconsistency over whether it's a municipality's responsibility or the county sheriff's responsibility, depending on where they are convicted, will cause great concern as well. I just want to simply highlight in closing out, we don't want any victim ever in the future to feel as though we didn't do what we could to see justice done or to see them move forward without the fear of future harm or future abuse from the person who attacked them. This bill only provides our concern is the bill provides a false sense of security, and that we're attempting to attest that we seized what we think was a complete picture. We can't ever guarantee that we've gotten a hold of every firearm. I also do think that we're going to run into in the future search issues, concerns over whether a warrant should or shouldn't be issued. Most of us are going to err on the side of caution and back away, which may cause us to miss something that we shouldn't have, attempting to force this. As Sheriff Easter's written testimony stated, we're happy to visit with anyone we can to help try to clean up some of the inconsistencies. And if there are questions that I can answer, I'm more than happy to stick around. Thank you, sir.
Thank you, sir. This is an opportunity for members to ask questions. Representative Smith, and feel directed to one of the four.
Yes, thank you, Mr. Chairman. My question is for Judge Wheeler. Sir, in my opinion, even if a warrant were issued, that could be, in my opinion, challenged. That allows a law enforcement officer to go to a home and demand to search for weapons that may or may not be present. In your professional opinion, and I understand that everyone can have one, but sir, your experience is noted here when I ask this question. In your opinion, would a search warrant be valid for such a search? And in absence of that, does this not create a great deal of liability on the officers involved in the search or conducting the search, let alone the court? Thank you.
There are probably a lot of perspectives about search warrants. Search warrants can only be issued upon a determination of probable cause. And the primary question we would have about the issuance of search warrants is whether or not that probable cause exists. If it does not exist, then we cannot issue the search warrant. And in the case of many litigants, they're not going to bring us information sufficient to have a search warrant issued. The second comment we'd make, though, generally about search warrants is that a judge may issue a search warrant, but a law enforcement officer is not obligated to actually exercise that search warrant. That only gives them the authority to do so. And we, as courts issuing search warrants, are not guarantors that those search warrants will actually be executed. Have I answered your questions?
I believe so, sir. I guess the second part of my question regards liability for officers who demand a search under this pretense. Let me be clear, without a warrant.
I would think that the search without a warrant is going to have to fall under the same controls that warrantless searches now exist. In other words, a warrantless search is per se unreasonable unless it meets one of several exceptions. plain view, exigent circumstances, things of that type. I would think that if an officer exercised the authority to search without a warrant, obviously liability concerns come into play.
Thank you very much. Thank you, Mr. Chair.
Thank you. Next question will be Representative Reese.
Thank you, Mr. Chairman. I'll direct this question to Dennis Butler. Mr. Butler, you made a statement that you would share the goal of the Mother's Demand Action. How would you approach this situation?
Can you say the
You said you shared the goal
Yes.
under this law. How would you approach it differently?
The bill, this is a big topic. This is a big question. Enhancing services to survivors of domestic violence takes many forms. Victim advocacy, helping them access services that we don't possess, for safety planning. So if they're in a situation where they feel unsafe, how do they extricate themselves and their children from that? The problem, which is, you've heard many of the problems, especially my testimony, there's no question that law enforcement supports survivor safety. How we go about it, the scope of our authority is what the question is here in my mind, and the number of resources that would be required the way this bill is constructed to carry that out. I forget which, I think it was Under Sheriff Cole Presley mentioned the issue of, did we collect everything that we think exists in terms of a weapon? And there's really no way of knowing that, and obtaining a search warrant really always requires a specific item to be found in a specific or general place based on probable cause. And the way this statute is written, it really doesn't allow for that. It doesn't require that. So we have no guarantee. One of the things was the victim, or excuse me, the defendant is supposed to attest to the fact that he has turned over all of his weapons. Defendants lie to us a lot. I don't know if you realize that, and I don't mean to be sarcastic, but it's very common for them to lie. But what are the penalties for that? That's silent in this bill as well. If they say, I don't have a weapon, and we say, okay, and we walk away, but they do, and we find out later that they have weapons, what's the remedy for that, other than an arrest for possessing it when a court order prohibits it?
Thank you for that, sir. And my last question, I will be brief. Would you dialogue with Mom's Demand Action on maybe in other law enforcement to compose a bill that may be more suitable for law enforcement?
I'm happy to talk to anybody about how we can enhance survivor safety lawfully and within the constitutional guidelines that we are required to operate under.
Thank you. Thank you, Mr. Chair.
Thank you. Folks, I do notice I got a couple of other questions. I'm going to ask you to hit them offline. You have their contact information of all the proponents and opponents. I will also indicate that there is one written opponent and one written neutral. Anyone else appearing here today that wishes to offer any testimony on House Bill 2251? Seeing none, I will close the hearing on House Bill 2251, and I will open the hearing on House Bill 2422. With that, I will direct it to the reviser committee. We have a number of proponents here, again, because of our time restraints, and this is actually the last committee hearing we will have on other bills other than the specific bill that we've previously been working. This was probably our last committee hearing before veto session. And then in veto session, we may not have one. But with that, reviser, if you'd give us an overview of House Bill 2422.
Thank you, Mr. Chairman. And before I jump into that, if I can take 20 seconds to quickly answer
Yes.
Representative Wagner's question.
Yes.
So the crimes that make somebody unlawful for them to possess a firearm, if committed within the last, or convicted within the last 10 years of murder, manslaughter, kidnapping, aggravated assault or battery, criminal threat, robbery, or burglary, felonies related to controlled substances, and non-person felonies if there was a firearm in possession at the time of that crime. So On to House Bill 2422. The bill amends KSA 232505 concerning age of consent for marriage. Under current law, a marriage license is prohibited from being issued to any person under the age of 18 unless one of two circumstances. One, that person is at least 15 years of age and a judge gives consent based on a determination that it is in the best interest of the person. Or two, the person is at least 16 or 17 years of age and either all living parents or legal guardians consent, or at least one parent or guardian and the judge consent to the marriage. So that's current law. House Bill 2422 would strike those exceptions and simply require that an individual be 18 years of age to obtain a marriage license. Happy to answer questions.
Thank you. Questions of the reviser? Seeing none, I will, I'm looking at the clock. I know the Senate Judiciary Committee is coming into this room at 10:30. We will stop at about 10:22 to give them opportunity to set up. With that, the proponents are Laura Van Wagner, I believe is present here today. Please come forward, ma'am. We do not limit written testimony, but you're going to be limited today. I'm going to try to get us through as many as I can, but you're only going to get 2 minutes, 2.5 minutes.
Thank you, Chairman, for the opportunity to address this committee today. My name is Lauren Van Wagner, and I am speaking for myself. I actually requested that this bill be drafted because I was a child bride. Today's actually the 2nd anniversary of my divorce, so it seems fitting that I'm here before you today. In November of 2006, my mom drove me to school. I turned in a research paper, and I was promptly checked out, where my 21-year-old boyfriend and I drove with my mother to Florida, and I was married. I was 17 and a senior in high school. At that time, my father was unaware that I was going to be married. They had shared legal custody. He found out several months later. You can only imagine how he felt knowing that his minor daughter was now married to a 20-year-old or 21-year-old man he'd never met. The next 12 years of my life were a horror story. I dealt with abuse, lies, and infidelity in my marriage. During that time, sorry, this is a hard topic for me to speak on. In 2018, my husband abused me in front of my children, and he walked out the door, and for the first time in my entire life, I was alone. I didn't know what to do. I didn't have a vehicle, and I lived in rural Kansas, and I was left with 4 children. My entire adulthood had been dedicated to my household and to being a mom. Suddenly, I found myself without any kind of job skills or college education and having to figure out what to do. I sold my house and I moved to town. But you see, I'm one of the lucky ones. Many women don't have that opportunity. Between the years of 2000 and 2010, 2,500 minors were married here in the state of Kansas. Many of them get trapped in a cycle of poverty and abuse because they can't escape. I complied with my marriage because I didn't see another option. I thought I was doing what was right by my religion, and I felt in my heart that it was the thing that was right for me. But the truth is, I wasn't mature enough to make that decision. I was only thinking of not having a curfew. I wasn't thinking of the role that came with it. Committee, as you can imagine, the last month has been emotional for me. It has been very hard to replay this trauma. But I thank you for the opportunity to speak to you today on this, and I'll be happy to stand for questions at the appropriate time. Thank you.
Thank you, ma'am. Next up is Max Robbins, Students Against Child Marriage on Webex. Max?
Hi, Chair Barker and distinguished committee members. Thank you for considering HB 2422 and giving me the opportunity to provide testimony in strong support of this legislation. My name is Max Robbins, and I'm the founder and executive director of Students Against Child Marriage, a student-led 501c3 nonprofit that's fighting the American child marriage crisis through student activism. Today, I will be briefly discussing the fundamental nature of this issue. Simply put, child marriage is a human rights abuse and has been called such by the United States State Department. The negative impacts of child marriage are profound. Girls and women in the U.S. who marry before 19 are 50% more likely than their unmarried counterparts to drop out of high school, and over 4 times less likely to graduate college. Girls in the U.S. who marry young are 31% more likely to live in poverty when they are older. And if that's not enough, women in the US who marry as children face a 23% higher risk of significant health complications. Now, that's not even to mention the prolonged psychological complications and frequent domestic violence that survivors suffer through. I'll lastly note that these outcomes are even worse for pregnant teenage girls, with those married before 18 having a 70 to 80% chance of getting divorced. Chair Barker and the members of this committee, child marriage is unequivocally a human rights abuse. Before you today is a rare, common sense, no-brainer of a bill. This legislation, it harms no one. It costs nothing, and it ends a human rights abuse that is happening here in each of your districts. These marriages are not teenage love stories, as you just heard, but rather young girls being forced into harmful and abusive marriages with much older men. Though there are absolutely instances of child marriages which go on to be lifelong and the start of incredible families, I know I have them in my family, these are unfortunately the exception and not the rule. Now, I think we all owe a huge debt of appreciation and gratitude to the courageous survivors who have spoken today and are going to continue to speak today about their stories. And I'll note that for each of them, there are countless others who are not in a position to come forward about their stories. The nation's youth urge you to vote yes. Thank you.
Thank you. Up next, we have Michelle Hanhash with Unchained at Last on Webex. Michelle, are you on?
I am. Can you hear me?
Yes, and if I misspoke on your last name, please correct me.
No problem. Chair Barker, distinguished committee members, thank you for allowing me to testify today in strong support of HB 2422. I'm Michelle Hanash. I'm the Director of Policy and Advocacy at Unchained at Last, where we are fighting forced and child marriage in Kansas and throughout the United States. And we also provide direct services, and it's important to note, to child and forced marriage survivors. We're founded by a forced marriage survivor in order to assist other forced marriage survivors. And we actually started being contacted by minors who were facing impending forced marriages. And we soon found that there was nothing we could do to help them. And when these girls learned of their limited options, they would despair and actually often turn to suicide. And so that is why we're here. You heard that the marriage age is 18 and that they're dangerous loopholes. To explain what that means, parental consent is often parental coercion, because what we know is that when a child is forced to marry, it's typically her parents. The issue with judicial approval is that a child who is forced to marry is also forced to lie to the court. And in fact, none of the victims we have ever worked with actually ever alerted the court that they were being forced to marry. Additionally, for a 15-year-old, the court has to find that marriage is in the best interest of the child. But as you heard, marriage under 18 is actually a human rights abuse. So how can a court find that that marriage is in the best interest? I'll also point out that typically sex with a 15-year-old is actually a crime, but not if the perpetrator actually marries the child first. So that marriage license actually acts as a get out of jail free card for a would-be rapist in Kansas. So again, how could that court find, even if it's rape, that that would be in the best interest of a child? Another alarming loophole is that marriage automatically emancipates 16 and 17-year-olds regardless of their level of financial independence or emotional independence. And you just heard the marriage divorce rate for child marriage is 70 to 80%. So that actually leads to teen homelessness. And so the first overarching major reason to end child marriage, aside from the fact that it's a human rights abuse, which you heard, is that it can easily be forced marriage. So children, until they turn 18, even if they're highly mature, do not have legal capacity. They can't leave home, they're runaways. They can't enter a domestic violence shelter because typically they're turned away if they're an unaccompanied minor. They can't retain an attorney
I'm sorry,
because—
your time is up.
Thank you so much.
Next, we have Nancy Zalzewski, maybe, with Berg International Academy of Family lawyer on Webex. Nancy, are you there? Nancy?
Yes, I'm sorry.
Oh,
sorry for the
great.
delay. It's Nancy
no problem.
Zalewski
You have
Berg.
2 minutes.
I'm past president of the International Academy of Matrimonial Lawyers. Recently passed was the woman who brought this initiative to our attention, Anne-Marie Hutchinson, Order of the British Empire. Anne-Marie was an amazing, courageous woman who traveled to some of the most dangerous places on our earth throughout the Middle East to try to rescue girls who had been forced into marriage. Girls whose marriages were arranged to accomplish an immigration of an older, sometimes a relative, sometimes related to the amount of the dowry being proffered, and so on. So she taught us so much, and it's a tragedy that we've lost her so soon. But I want to let you know that it is a problem in this country, and I'm not going to reiterate everything that all of these others witnesses have testified to, because I think, frankly, I've sat through your committee meeting this morning, and you've learned a lot about domestic violence and domestic abuse and the risk it poses to our children. So I'm asking you to please pass House Bill 2422. It's important, it's necessary, and it's part of a movement across the country. Thank you.
Thank you, ma'am. Next up, Amanda Parker, AHA Foundation, Webex. Amanda, are you on Webex?
I'm here. Can you hear me?
Please go forward, 2 minutes.
Thank you so much. Hi, I'm Amanda Parker. I am originally from Kansas, so I am especially proud to be here to speak with you all today. I'm a Dodge City High School graduate and a Kansas State graduate as well. But now I'm the senior director for the AHA Foundation, which is a national organization working to end harmful practices in the U.S., including forced and child marriage. We were also founded by a forced marriage survivor. I want to talk to you today about the fact that under Kansas state law, 16 and 17-year-olds who marry are automatically emancipated upon being married. Now, unfortunately, that emancipation does not help them to avoid a forced marriage, because they actually have to be married prior to that emancipation kicking in. So individuals who are minors who have been forced to marry are forced to endure the trauma of likely being raped on their wedding night, probably being taken out of school. So they're forced to endure unimaginable trauma prior to being able to be emancipated and hopefully be able to get themselves out of that difficult situation. But 15-year-olds who are forced to marry are not even emancipated. They don't even get those limited legal rights that are offered to 16 and 17-year-olds. So I just want to make it very clear that even though minors who are 16 or 17 are emancipated, that does nothing to protect them from a forced marriage. And I really just want to say that I'm here in strong support for HB 2422, and thank you so much for your time today.
Thank you. Next up is Dawn Tyree, Webex. Dawn, are you on Webex?
Yes, can you hear me?
Yes, we can. Please go forward.
Thank you, Chairman and distinguished members. In strong support of HB 2422. My name is Dawn Tyree, and I'm a survivor of child marriage. My marriage took place after I was being sexually abused by my nanny for 2 years. I was 13 years old and he was 32 years old. Child marriage was a decision that was made for me, not by me. Minors don't have a voice, and they're often not going to be able to speak out against their families or their abusers. Child marriage destroyed my life. I was pulled out of school to be a wife and mother, and like many of you, my ancestors married young. It wasn't uncommon, but I think we can agree now that we want more for this generation. As a child bride, I had no rights over my body, resulting in 2 children by the time I was 15 years old. I escaped with my 2 children when I was 16 years old. That's where I endured most of my hardships, 16 and 17 years old. My marriage was an automatic emancipation, yet I had no legal rights. My husband reported me as a runaway, and when law enforcement caught up with me, they threatened to take me back to my husband. I couldn't rent an apartment, a hotel room, or even enroll myself back into school. I needed my ex-husband to sign the documents for me. My divorce wasn't actually finalized until after I turned 18 years old. I had no support from my family, since my family was the one behind the marriage. Developing countries do more to protect their children from child marriage than we do here in the U.S. A marriage is based on love with 2 consenting adults, and children are not consenting adults. Our laws must reflect our values. Children are the right holders of these laws, and we're failing them by not enforcing them. Thank you for your time.
Thank you, ma'am. Next up, and I'm going to need some help on this, It's Rima Nashha. Are you on?
Yes,
And
yes, I
please help
am.
me. And your last name is pronounced?
Rima Nashashibi.
Thank you very much. I'll try to remember that. Please go forward. You have your 2 minutes.
Thank you. Honorable Chair Barker and distinguished members of the House Federal and State Affairs Committee. My name is Rima Nashashibi. I'm the founder and president of Global Hope 365. I rise to speak in support of HB 2422. Global Hope is a 501c3 nonprofit organization dedicated to ending harmful practices against women and girls like child marriage and human trafficking. You heard what everyone says. I mean, we work with survivors. Some of them are 50 years old and so they still have nightmares. We just had a Senate meeting yesterday, and if you hear the survivors tell their story, your heart will break. They still have nightmares about their experience. But I submit to you that the American Medical Association has called for an end to child marriage, stating child marriage is associated with higher rates of sexually transmitted infections, diseases, early pregnancies, divorce, and intimate partner violence, and infant and maternal mortality than women married at age of 21. Also, the United Nations Office on Drugs and Crime issued a report recently on the interlinkages between forced child marriage and human trafficking, which we all know involves fraud, force, and coercion, and benefiting commercially by the receipt of payments from the use and abuse of another human being. So please,
Rima,
I
30
urge you
seconds.
to vote. Thank you. So please, I urge you to vote yes on 2422. And please protect the children of this great country. When the Department of State issues a report saying it's human rights abuse in other countries, what about our kids? What about our children? What about us here? Thank you so much.
Thank you, ma'am. Next up is Sarah Tesney. Sarah, are you on Webex? Or are you present? I don't have a listing on Webex, and she does not appear. All right. Anyone else would like to offer any testimony as a proponent? Committee, if you'll look on your agenda, there's a number of written proponents. I have no opponents listed. Anyone appearing as an opponent to House Bill 2422? Again, seeing none, I will close the hearing. Well, take that back. I'm a little premature here. Is there questions of the proponents? Yes, Representative Howell, if you'll direct it to one of the individuals.
Thank you, Mr. Chairman. This question is for Lauren Van Wagener.
She's present. She can come up. Thank you.
Ms. Van Wagener, I appreciate your powerful testimony today. You're clearly you speak very well, so I commend you for that. But is there a specific religious denomination or sect that this is a prevalent problem in?
I would say that it's probably in many conservative religions it's a problem. I myself was Mormon. My mom found out that we had been intimate, and so she felt that in order to save my ex-husband's priesthood and his standing in our church that we should be married, and that was one of the reasons I agreed.
Thank you very much for your testimony.
Ma'am, I have one question. What was the duration of your marriage? How long? I didn't
12 years.
12 years. And there was children of the marriage?
Yes, I have 4.
Okay. And you were left all alone?
Largely, yes.
Okay. Thank you. You are to be commended. It was 4 children. Thank you. And I agree with the previous representative. You are well spoken. Representative Clayton.
Thank you, Mr. Chair. My question is for Nancy Berg, who's on Webex.
Nancy, are you on?
Still there?
Nancy?
I'm here, sorry.
Oh, okay, good. So I just wanted to ask a question because again, I am the one that brought this legislation. I think it's always something we should consider. We talk a great deal in this committee about when should certain rights be conferred. We've had this discussion regarding firearms and earlier regarding who should or should not run for office. I am a strong supporter of the institution of marriage. It'll be 20 years for my husband and I this October. And I see child marriage as a potential threat to the institution. So my question is do you have any statistical data about the divorce rate for these younger marriages, for these teenage marriages? And if so, if you could share that with the committee?
I believe it's contained in the testimony from the Taria Justice Center. And I know I heard someone else's testimony that it was 60 to 70%. I think the most significant issue here is really these children have nowhere to go for help. Child protection is mandated to reunite them with the family that may have put them at risk. They can't go into a shelter. So that's the danger of the underage marriage, is there is no recourse for that child who is still a child to obtain help.
Thank you. Thank you, Mr. Chair.
Thank you. As promised, we would try to get out of here at 10:22. I believe we're hitting that mark. As I indicated earlier, there are no opponents. If you wish to have additional questions, you have their contact, all the conferees' contact in their testimony. Please, if you have questions, contact them. With that, I will close the hearing on House Bill 2422. Committee, Monday, we're starting at 8 o'clock. We will be in this room, and we will continue to go forward. Anything else for the good of the committee? Seeing none, we are adjourned.